I want to begin by congratulating you, the audience, for your attendance today. It speaks well of your engagement in the political process, and we'll be discussing issues that normally generate strong feelings from supporters on both sides. I'm confident that this forum will demonstrate that despite the divisiveness that surrounds our country, we can and indeed we must work to practice decorum and respect for each other. And I'm confident we'll do that today. Although we have different points of view represented, our purpose today is not to debate, but rather to elevate the dialogue by shedding light on the legal issues involved and providing useful information about where we have been, where we might be going, and the process involved to get there. We have a full program that will likely fill our allotted time. However, if time remains at the end, we invite you to record your questions on the cards distributed. And please raise your hand now if you need a card, if you think you might want to ask a question and need a card. I think we pretty much put them out. Where's our young man that's distributing? There he is right there in the blue shirt. Put your hand up and he'll give you a card. Okay? And then we'll provide a time when they can be collected. Okay? As the moderator, I will screen the questions for redundancy and do the best I can to provide fairness from the respective points of view. And we're not here to play gotcha. So gotcha questions, save your pencil. We're not going to do it. Okay? We're here to elevate the dialogue and understand each other. We've assembled an excellent panel to discuss issues of reproductive rights and election procedures because they are soon to become so strongly interrelated. Our panelists include, John Petito, Bucks County Community College Associate Professor. John, if you want to wave to the crowd. Dave Steil, former 8-term state representative from the Yardley-Makefield area. Patrick Christmas, the policy director from the Committee of 70, which is a nonpartisan good government committee in Philadelphia. Patrick. Marlene Downing, the Susan B Anthony List and Bucks County Pro-Life Coalition. Marlene. And Melissa Reed, who is president and CEO of Planned Parenthood Keystone. So we have an excellent panel, and they've given their time today, and we appreciate that. In 1973, the United States Supreme Court, in the case of Roe versus Wade, ruled that state statutes criminalizing abortion violated a woman's constitutional right to privacy, which it found to be implicit in the liberty guarantee of the Due Process Clause of the 14th Amendment. That was basically the basis for that ruling. In 2022, in the Dobbs decision, the court reversed itself, ruling that the Constitution does not confer a right to abortion and returned the authority to regulate abortion to the people and their elected state representatives. At the same general time that the court was placing the authority of abortion regulation with the states, it was also limiting the authority of the federal government to regulate election laws and procedures, granting more flexibility to the states. So today we're going to discuss 3 issues. 1, the constitutional reasoning behind each of the abortion rulings. 2, the current Pennsylvania law regulating voting and election procedures. And 3, the legislative goals of the pro-life and pro-choice advocates as we move into 2023. So for part 1, we'll begin with question 1 and defer to Professor Petito, former State Representative Dave Steil, to address the constitutional foundations of Roe and Dobbs. So we'll start with Professor Petito.
And thank you, Bill Pezza, for doing this every Constitution Day for, I think, about 20 years. It's a wonderful opportunity for the community. For any of my former students here, you'll be amused because I'm going to read most of my speech today, and I always tell my students, never read to an audience. It's just a terrible thing to do, but this is too complicated for me to do more informally. So excuse me, because I'm going to read a good bit of it. I also know today that for every word I utter, there is another side to the coin. There's another perspective, there's another argument. I'm just going to try, and as best I can, simplify some very complicated issues. I'm going to do it from an historical viewpoint and try and avoid cluttering it with too many legal details. Why? Because there are too many legal details. And it'll just get us, none of us will learn anything. So I understand there are different points of view on this. With this summer's Dobbs decision that reversed Roe v. Wade and other decisions that held that there's a right to abortion, you kind of can stand on a mountaintop and look back over the last 60 years to see there's a story here. It started with a simple question. The question was, does liberty include the notion that people are entitled to privacy and to make private decisions in the best interest of themselves and their families without interference from any government? I'm going to read that again because that's where all this started. Does liberty include the notion that people are entitled to privacy and to make private decisions in the best interest of themselves and their family without interference from any government? The issue in the Griswold case was whether people could use contraceptives. The answer then was yes for married people. But that simple question grew ever more complex in the 58 years since the Griswold case was decided. The questions continue. Does liberty mean we have a constitutionally protected right to privacy, one that includes the right to take contraceptives even if we aren't married? Is sex a privacy right, something consenting adults can do in private, even same-sex sex? Does liberty include a privacy right to choose whom we marry, even someone of the same sex or of another race? Looking back, we can see that for most of the years since 1965, under scores of justices nominated by Republicans and Democrats, the answers to these questions were yes, yes, and yes again, as liberty was expanded to include the right of privacy, and privacy was defined to include fundamental decisions like whether to have children or not, or how many, or when to have them. Decisions like whether to have sex or not, and with whom and how. Or decisions like whom to marry. Can people marry outside the race, and can they marry people of their same sex? Most notably in the 1973 decision in Roe v. Wade and the 1992 Casey decision, this train of constitutional thought also protected the right to abortion for unwanted pregnancies. Looking back, this was an era of expanding rights for persons living in the United States. Criminal statutes were being thrown out and replaced with constitutional protections for all these newly recognized rights arising from the notion that the Constitution protects privacy. Remember, these activities were crimes. Using contraceptives, having same-sex sex, interracial marriage was a crime. Abortion was a crime, and the Supreme Court turned those crimes into constitutionally protected activities. That era of expanding liberty rights came to a screeching halt this year when a brand new majority on the court looked at the same Constitution as all the other judges had and held, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. The court sent the legality of abortion back to 50 state legislatures to decide whether to allow abortion, or to regulate it, or to criminalize it. The court held that shorn of any constitutional protection, abortion could be regulated just like any other medical procedure that states regulate or criminalize, just so long as they have a reasonable reason to do so. For instance, the majority helpfully suggested, quote, respect for and preservation of prenatal life at all stages of development, end quote, is reason enough to legitimize a ban on abortion after conception. How did this come about? Reversing 50-year-old precedents is very rare, or at least it should be. Reducing a right to a mere regulation is rarer still. The Supreme Court reverses itself now and then, sure, but Dobbs may be the first case in recent U.S. history where the court took away a right, restricting the liberty of Americans. Let's go back a bit to see if we can understand how this happened. In 1965, the year before I graduated from high school, Connecticut had a law that banned the possession or distribution of birth control devices. Mrs. Griswold, a married woman, was convicted of violating this law. Justice William Douglas, perhaps the most liberal justice ever to sit on the Supreme Court, wrote that the Connecticut law violated Griswold's right to privacy, holding that the 14th Amendment protected the liberty of married people to use contraceptives without government interference. Here's the problem, and it's the same problem that led to the reversal of Roe v. Wade. The Constitution does not mention birth control. It doesn't mention abortion, nor does it mention privacy. That did not deter Justice Douglas in 1965, who wrote that the first 8 amendments to the Constitution, get ready for this, you're not going to understand it, that the first 8 amendments, quote, have penumbras, formed by emanations from those guarantees that help give them life and substance. In short, he said, there are more constitutional protections than just those named in the Constitution. These are called unenumerated rights, unnamed rights, implied rights, imputed rights, even though they're not the word privacy is not mentioned in the Constitution. What is he talking about? Penumbras, a penumbra is a shadow, and Douglas was saying that the named rights in the Constitution cast shadows that define different ways that liberty can be exercised. After all, ask yourself, what does liberty mean? What does liberty mean? Freedom? Freedom to do what? It's a vague term. And as we'll see, over time, and despite bitter disagreements, the justices agreed that the rights guaranteed in the First Amendment to the Constitution were liberty interests. That's what they are. They're liberty interests. That's what the word liberty means. So far, they said whatever the rights were in the first 8 amendments of the Constitution. Things that are named, like freedom to bear arms, freedom of free exercise of religion, freedom to express yourself. Those are named rights. The problem was that those freedoms, the ones named in the first 8 amendments, were protections only against the federal government, the new United States of America. That's because our founders were fearful of this new federal government. They were creating a powerful central government, distant from most of the people they would rule. When the states convened to draft the Constitution, the Bill of Rights, they were not afraid of New Jersey or New York or Maine or Georgia. They were afraid of this new federal government they were creating. That's why the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise. Congress shall make no law. It didn't say the states to make no. It said Congress. It was limited to constitutional rights protecting us from the federal government, not from the states. The problem was that the Bill of Rights did not protect the citizens of the individual states. They only protected us from the federal government. Congress shall make no law. So far, so good. Until the Supreme Court realized that the states were repeatedly violating rights guaranteed by the Bill of Rights. So, for instance, in cities like Chicago, the Chicago police were routinely raiding gambling parlors or brothels or nightclubs without bothering to get a warrant, as required by the Fourth Amendment, or maybe they were beating confessions out of people, despite the Fifth Amendment right against self-incrimination. What to do? These weren't federal officers, these were state officers. That's when the court began to selectively incorporate one by one certain of the named rights in the first 8 amendments. They incorporated them into the 14th Amendment. What? Did anybody understand what I said? Of course you didn't understand what I just said, unless you're a lawyer. That's the way the lawyers talk. That's why I wanted to avoid wading too deeply into this. But let me tell you about the 14th Amendment. The 14th Amendment reads in part, nor shall any state deprive any person of life, liberty, or property without due process of law. That's why it's called the Due Process Clause. Liberal justices, those with an expansive view of rights, began specifying what was protected by the word liberty in this clause, define it specifically, and they overturned state laws that deprived people of these liberties. There's another problem here that I won't wade into, and you may be asking, well, what is due process? For our purposes today, it means that some liberties are so fundamental as to be beyond the state's ability to regulate them. Again, don't try and figure it out logically. That's just what the court decided. So stay with me. It was the Griswold decision by Justice Douglas in 1935 that held under the 14th Amendment a state could not deprive a married woman of her right to use contraceptives because that was a fundamental liberty interest protected by the 14th Amendment. That's a great result if you favor an expansive view of the Constitution. But Douglas's reasoning was described as an imaginative rationale, in the words of another liberal justice, John Paul Stevens. Other justices said that his rationale was just unnecessary. Penumbral rights, penumbras and emanations. Yet that awkwardly worded decision is the pillar upon which many other rights rest. The idea that there's a right to privacy, the right of single women to use contraceptives. It's a privacy right. That's Eisenstadt versus Baird. The right to marry a person of a different race. Maybe you saw the movie, Loving versus Virginia. The right to choose an abortion, Roe v. Wade and Casey. The right of gay people to have sex with one another, Lawrence v. Texas. The right of gay people to marry, Oberfelder versus Hodges. All based on the right that the Constitution, through the 14th Amendment, guarantees us a privacy right. The question to be decided now is whether the new majority on the court will apply the rationale they used to overturn Roe to overturn Griswold and these other cases that I've just mentioned, because none of those rights are spelled out in the Constitution, nor are they mentioned. Privacy isn't mentioned, contraceptives aren't mentioned, marriage is not mentioned, sex is not mentioned. Do we have those rights? They aren't in the Constitution. They were read into the Constitution through the 14th Amendment, and now the Supreme Court is telling me that's not happening. If they weren't mentioned in the Constitution, they aren't rights. That's how Roe got overturned. Now, I have to tell you that in his majority opinion, Justice Alito went out of his way to say that those other rights are safe because they can be distinguished from abortion by one fact: none involves the loss of potential life. Justice Kavanaugh's concurrence also reassures us on this point. The other rights are safe, don't worry. But Justice Clarence Thomas, in his concurrence, says just the opposite. It's now time that this court do away with every right that is not named in the Constitution. Two exceptions, I won't go into them. He did leave some room for how you could have an unnamed right as a constitutional right. But his view was, if they're not in the Constitution, they aren't rights. If my suspicion is correct that the other so-called privacy-derived rights are in danger of losing federal constitutional protection, our Pennsylvania legislature and courts will be very busy in the decades to come deciding whether Pennsylvanians have a right to an abortion, or to use contraceptives, or to have sex with any adult they choose, or to marry anyone they choose. So whatever your political party or your personal views or your values, it's imperative that we know where candidates stand on these issues and that our voting procedures are fair. This is because it will be Pennsylvania lawmakers who will decide whether Pennsylvanians have any privacy-derived rights at all. Not through the 14th Amendment of the U.S. Constitution, but as reserved rights retained by the states under the 10th Amendment. And former Representative David Steil is going to tell us a little bit about the 10th Amendment. Thank you very much.
Thank you, Professor Petito, for a very, very reasoned and comprehensive review of how we got to where we were. There's two pieces of the Constitution that maybe I can simplify it a little bit more. The Ninth Amendment, after the Founding Fathers listed the Bill of Rights in the first 8 amendments, and we're familiar with them, search and seizure, religion, press, and whatnot, the Ninth Amendment says specifically, the enumeration of the above rights shall not be construed as the only rights retained by the people. They had a good sense of humor. They didn't tell us what those other rights were, but they said there are other rights. And that's what we often refer to as the Implied Rights Amendment. And one of those rights is liberty, at least in the opinion of the court, and then the Liberty Clause of the 14th Amendment. And the 14th Amendment also says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So as federal citizens, if we enjoy a right, a state cannot take that right away. So those were two relevant pieces of the Constitution that supported the Roe ruling. The 10th Amendment, which Dave Steil is going to talk about now, is called the Reserved Powers Amendment, and it says powers not granted to the United States are reserved to the states. So we have two conflicting pieces of the Constitution here. The 9th Amendment, implied rights, the 10th Amendment, reserve powers saying if it's not expressly spelled out in the Constitution, it's reserved to the states, and that's the one that Alito and the court hung their hat on for this ruling. So let me introduce David Steil, who's going to talk to you about the evolution of the 10th Amendment. We're trying to take what would normally be an emotional issue and also bring in the very complicated legal aspects of how we got here.
Thank you, Bill, and thank all of you for being here today. This is a critical discussion and one that personally many of us have been involved in for years. So what I want to do this morning is kind of take us through the development of the origin of the 10th Amendment. Where did it come from? Why do we have it? And what was the reasoning behind it? So in a way, this is going to be a history lesson. Originally, most of us are familiar with the fact that in the colonial period, our various states, and I'm going to call them states rather than colonies, but most of us are familiar with the fact that they organized and proceeded to do and decided they could do business under something called the Articles of Confederation. The Articles of Confederation, however, had no legal status. The states were still supreme and sovereign, and Congress was subordinate. But this began to raise some problems, not only in the conduct of the war, because effectively there were 13 decision makers in each of the states. And as just an aside, I can imagine someone going up to George Washington and saying, "Hey, I understand you got 13 bosses. How's that working out for you?" Well, probably not very well, and that was the problem in the conduct of the Revolutionary War, is that the states could not agree on many issues, one of which was to raise money. But this really became a problem in 1783 when the Treaty of Paris was signed, which ended the Revolutionary War. In effect, however, there was no authority for that treaty because none of the states had individually approved the treaty or granted the power of the negotiation to those who negotiated the treaty. So it became clear that states could ignore Congress. The drafters had been mistaken and had expressed the confidence in the Articles of Confederation. They expressed confidence in the justice, good faith, honor, and sound policy of the individual states that would overcome the differences that they may have had. Obviously, that didn't work out so well. So in 1787, in May, a constitutional convention was convened. Initially, when the Constitution was debated and ultimately decided, the Constitution did not have a Bill of Rights. So when the Constitution came to the states for approval, again, without a Bill of Rights, there were many objections because many states had bills of right in their own constitutions. And they protested that they could not approve a constitution that did not have it. So there was many arguments about it, including James Madison, who argued in the Federalist Papers. And if you're not familiar, the Federalist Papers are some 80 letters that were written by John Jay, Alexander Hamilton, and James Madison that tended to support and reasoned why the clauses of the Constitution were as they were. Madison said that we don't really need a Bill of Rights because there are checks and balances within the Constitution, and that will make sure that everybody's fair, everything takes place as it should. Well, that didn't work. So many states said, we won't sign or approve, and they needed 9 votes. They needed 9 states to approve the Constitution before it could go into effect. Luckily, they decided they didn't need a unanimous vote because they couldn't get a unanimous vote. Some states said, we will approve the Constitution as drafted with the condition that you prepare a Bill of Rights. And so that's what happened. The Constitution was approved, and in 1789, the Bill of Rights was adopted, which Bill and John have just talked about. We're primarily going to talk about the 10th Amendment, which reserves to the states the rights of all policies and procedures that are not defined in the Constitution itself. If they're not specifically allowed or prohibited in the Constitution, they are allowed to the states. But that creates a lot of controversy. And it defines a strong central government. It creates a constant struggle between the individual freedom and a strong central government. And the interpretation of the Supreme Court over the years has varied on that. Clearly, the Constitution puts sovereignty of the nation over that of we the people of the United States. It doesn't say we the citizens of the United States. It says we the people of the United States. So the issue is individual freedom and the rights of a strong central government. Early challenges were many to this 10th Amendment clause, but the one that really brought it to the fore and really was one of the major causes of the Civil War was the Fugitive Slave Act. The Fugitive Slave Act was adopted, actually there were some earlier adoptions, but in the Compromise of 1850 when there was a congressional compromise between the North and the South on how the issue of slavery would be dealt with and a number of other things, how states would be allowed to enter the Union. And those major challenges to the Fugitive Slave Law became ultimately the point that drove the Civil War, one of the points that drove the Civil War. Essentially, the Fugitive Slave Law said any slave who escaped their master, if you will, and found their way into a northern state where slavery was prohibited or not allowed in one way or another. The Fugitive Slave Act said all fugitive slaves are in effect can be arrested and returned to their masters. And the northern states said, no, we're going to rely on, this is a states' rights issue. We have the right to govern how we treat fugitive slaves. We don't have slavery. We don't need to return those slaves. The South said, it's in the Fugitive Slave Act. You agreed to it. Congress agreed to it. And so you must return these slaves. Well, there was never really a resolution to that. The two sides kept butting heads, and ultimately we had a civil war. After the Civil War, there was a major shift in individual rights by the passage of the Civil Rights Act of 1866. This created a major shift in individual rights from states to the federal government. In effect, it moved the redress of those questions to the federal courts. And the first thing it did was overrule the Dred Scott decision, which was a terrible decision that essentially ruled that African Americans were not citizens and had no rights. And so the Civil Rights Act of 1866 overruled the description of former slaves. The critical part about it is that this Civil Rights Act now applies to any person, not a citizen, but any person, which is language taken from the Fifth Amendment of the Bill of Rights. And as a result of that, we have now set up this conflict. There were many other challenges to the 10th Amendment and to the 14th Amendment, but ultimately it was the 14th Amendment which created the issues that we are now facing. So I'm going to leave it at that point. That's the history of it. That's where we are today. Thank you.
You know, I often get a kick out of when I hear citizens complain that we're not teaching history in the schools, that they want to know, are we telling students that, that whether or not Betsy Ross went to sewing class and what was the name of Paul Revere's horse. We're busy doing things like this. We're busy doing high concepts, and I hope you can appreciate that. So, having said that, thank you, Joe. Justice Alito, in writing the opinion in Dobbs, indicated that abortion decisions will be made by the people and their elected legislatures. We thought it would be useful to review then, this ultimately for us in Pennsylvania will be decided in the Pennsylvania legislature. So we thought it would be important and useful to review the current voting laws in Pennsylvania, as well as proposed changes in the legislature. To aid us in the effort, we call upon Patrick Christmas, the Policy Director of the Committee of 70, a nonpartisan group from Philadelphia. Patrick, you're there.
That's what we're doing today. Good afternoon, everyone. My name is Pat Christmas, and I'm honored to be here. And I guess I'm largely responsible for talking about the electoral implications of the landscape, this new legal landscape that we have. So, first, with regard to election law and voting procedures, currently, this is a fraught debate. I'm sure this is a highly informed group, and you've seen plenty in the news about kind of where things are. But it's worth noting, because we're talking about so much history here, that most of Pennsylvania election law is from 1937. The vast majority of it, which is very poorly written for another time, is from 1937. And the biggest change we've made to it since 1937 was in 2019. It was in October of 2019 when Republicans and Democrats negotiated a compromise deal that gave us a number of changes, big changes, a 15-day voter registration deadline. So before, it was 30 days before election day you could register. Now it's 15, which at least for voting access advocates, that's a good thing. It eliminated straight ticket voting. So before, on the machine you could hit a button at the top and vote straight D or straight Republican all the way down. They did away with that. And they created something called the Mail-In Ballot that has drawn all sorts of attention over the past couple of years. Now, the funny thing about the Mail-In Ballot is that it's basically a copycat of the absentee ballot. So we've had absentee ballots for decades. Absentee ballots are also noted in our state constitution. But what the General Assembly did, and what the governor approved, was basically the same steps and procedures for absentee voting and for the absentee ballot, literally copied that language and pasted it into another section of our state law to create the mail-in ballot. And because this was new, because this was October of 2019 and we had no idea how the world was going to change 4 months later, and because we probably could have anticipated some of the political divisiveness that would envelop us in 2020, but surely none of us realized how bad it was going to get. This has become a really big deal, where not most other states, but a lot of other states have widespread mail-in ballot use. There are actually some states where everybody gets a mail-in ballot. If you're a registered voter, every single registered voter gets a mail-in ballot mailed to them, which is absolutely not what we do here in Pennsylvania. I want to make sure that's clear, because with all the silliness, conspiracy theories, folks think their ballots running around in dump trucks. There's a specific series of steps you have to go through to request a mail-in ballot, and one of them, incidentally, is to provide voter ID. That 2012 voter ID law that we had, most of it was challenged and struck down. The one piece of it that was not challenged actually applied to absentee voting. And again, the absentee voting procedures we have were copied over into mail-in voting. So to apply for a mail-in ballot, you still need to show ID, which is, for application purposes, is simply your driver's license number, the last four of your social, or if you don't have either of those two, a copy of an approved form of photo ID. So I figured it'd be worth noting that election procedures have changed dramatically in Pennsylvania and over a very short period of time. And again, in other states where there has been for many years widespread mail-in voting, they were able to make that transition over a period of years without the political craziness, without a pandemic. And so county election officials, local election officials have been able to adjust, voters have been able to adjust, and those sorts of changes and those sorts of policies in other states have happened with relatively little fanfare. But of course, that's not the case here in Pennsylvania, which is why I think part of the reason I'm up here today. So as far as the way we vote right now, it really hasn't changed since that 2019 law. We made a few adjustments to get ourselves through the pandemic, especially June of 2020, which is a crazy one. But the mail-in ballot is still available despite all the litigation, dozens of lawsuits, dozens, just here in Pennsylvania around our voting procedures. We're still basically left with the same law that we passed in 2019. So for folks who are concerned about mail-in voting being struck down, for folks who are concerned about mail-in voting not being safe and secure, I would just stress that it is. It's just new. Interestingly, I'm sure something else we've heard plenty about is these mail-in drop boxes. Again, it's a feature of election infrastructure that is very, very common in other states, but here in Pennsylvania, it's new. And for whatever reason, it's become a bit of a boogeyman for some folks, because I don't know, it's new, and there's like a lot of political rhetoric around mail-in voting. But dropping your ballot off in a mail-in drop box, or at a post office, or a mailbox, it's all really the same thing. So there have been, because of this huge debate we've had over election law, which I guess is kind of a double-edged sword, because folks like us, we would have loved to be talking more serious about changes to election law, but now we're talking about them so much, and often in the wrong ways. It's often does more harm than good. But at this point, and with the upcoming election so close, it seems very, very, very unlikely that this legislature and this governor will agree to any further changes. So again, the law and the policies we've had for the past couple elections, those are the laws and policies we'll have in place for November. I'll flag just one thing, because this is like indicative of the debate we're having right now. There are lots of things to fix in our election law. Again, most of it's from 1937. Most of it was designed to bake in, to some extent, power for the two major parties. And then also, a lot of it was designed to ensure integrity of the election, because 100 years ago, early front half of the 20th century, there was plenty of voter fraud. There was plenty of voter intimidation. There's a lot of it. And the best mechanism to secure the election is to make sure both sides could oversee the election at the same time. Whether it's a county board of elections, which is bipartisan, or our local election boards, which are supposed to be bipartisan, the poll watchers, which are supposed to be bipartisan, the election observers at our central county locations that come from both parties and from or the several and numerous parties and the several and numerous campaigns. Despite that old law, there's a lot to fix. The one thing though, it's worth flagging, because if you do come across your state rep or state senator, this is worth noting. One thing more than anything else we desperately need is more time to process these mail-in ballots. So this got overlooked, which is what happens when the sausage making of legislators is happening. We did not give ourselves enough time to confirm a ballot received to a county is actually from the voter, to open up that outside envelope, to extract the inner secrecy envelope, to open up that envelope, to extract the ballot, to lay that ballot out flat, and then to scan it. It's a very manual process. Previously, it wasn't a big deal because it was only absentee ballots, and there weren't a whole bunch of them. But now in Philly, in a big election, we'll have 350 or 400,000 of these ballots to process, and that's part of the reason we needed some of that outside funding to survive the 2020 election, and other counties did as well. So with the volume of mail-in ballots we have to process now, and the fact that the current law doesn't let us start until 7 in the morning on election day, that means our counties have to spend extra time, extra money, not just on their own staff, but on overtime, on temporary personnel, and they have to process these ballots. They don't have to, but most of them do, constantly until they finish. So in Philly, in November 2020, those folks were working for about 3 days straight. A friend of mine who was in that office worked for literally 3 days straight. I think he got like 2 or 3 hours of sleep that whole time. And unfortunately, because this is a very nonpartisan administrative change, all they'd have to do is allow counties to start processing these ballots a week earlier, 3 days earlier. That very simple change has been wrapped up with all sorts of other items. Again, the drop boxes, voter ID, same-day voter registration. You name it. It's been we've had bills introduced on that topic in this General Assembly. So again, at this point, I don't anticipate anything changing, but we have a huge election coming up, right? And everybody here knows there's a very, very stark choice. Well, there are a couple stark choices at the top of the ballot, right? U.S. Senate and governor, and I'm sure everyone knows who's running for those offices. And at least for that gubernatorial race, right? Whoever we end up with, we're going to end up with a very different set of outcomes on a whole range of issues, including reproductive health and abortion access, but also on elections and voting. So I'll name one other topic here and then give up the podium. But it's also something else everybody here has to be very much aware of, is that because power is divided right now, and because our politics are more dysfunctional than they've been in a long time, if ever, this legislature and this governor have had a very difficult time finding common ground and compromising. And so as a result, and actually not just that, we've had some battles between this legislature and our Supreme Court. there has been a surge over the past several years of proposed constitutional amendments. So to amend our federal constitution, it's a very high bar, right? We haven't done that in a long time. To amend our state constitution, it is a much lower bar, which is not necessarily a bad thing, because we can keep our very old Pennsylvania constitution more up to date, easier than other states can. But to change our constitution, you simply have to pass a piece of legislation in one legislative session, which is 2 years long. Then we have an election. And then if you pass the exact same proposal, the exact same legislation, then that proposed change goes to the ballot. So we've done this about 50 times since 1970 or so, and most of these questions pass because voters often just check yes. And most of those amendments have been perfectly fine amendments to the Constitution. But we've had a surge. I think the count is more than 80, 86 maybe, the last count, just for this legislative session. A few of those amendments, maybe some of them, are perfectly reasonable. There may be merit-based arguments on both sides, but they're reasonable changes to the Constitution. A number of them are not good in that they're taking what should be in regular law or statute, sticking it into the Constitution, which is not what we should have. A proposed voter ID amendment, for example, right? I mean, we can have voter ID in our regular statute, but it should not go in the Constitution. And some of these proposed constitutional amendments would dramatically change the structure of government. One of them introduced this past couple sessions would break our judiciary into individualized districts with lines drawn by the General Assembly. That's a huge power grab by the General Assembly. Probably not going to happen, or that legislation is going to lapse in a couple months. But the surge of these amendments and the legislature's realization that they can basically pass new policy by changing the Constitution. They can also pull power back to themselves from the other branches through this relatively easy mechanism, is something that's going to be with us for a while. Until, and I've heard of, everyone's kind of trying to figure out what to do with the situation. We may elect lawmakers who will approach these processes differently, which doesn't seem likely given the political environment. Or we'll have voters, when these amendments come up, presumably pass the ones that make sense to go in the Constitution, the ones that preserve our fundamental checks and balances, and then strike down, vote against the ones that don't make sense to put into our Constitution. But this is tough because there's a lot of stuff on this ballot, and the amendments are always at the bottom. And some of these amendments will be going to the ballot, surely, in odd year elections when not many folks are voting. So the reason I bring this up is not just because it's critical to being an informed voter, but, and again, I'm sure some of you folks have seen the headlines on this, there was one proposed constitutional amendment, it's actually 5 distinct amendments, that was rushed through at 11 o'clock at night a couple months ago. And the funny thing about it was the kernel of it, the original proposal, was a completely legitimate change. It would allow a gubernatorial candidate to select their own lieutenant governor running mate, right? Perfectly legitimate change, arguments on both sides, but that's a real thing you can put in the Constitution, makes some sense. But they tacked on voter ID, which doesn't belong to the Constitution, election audits, which we already do, but that doesn't belong to the Constitution. It would allow the legislature to veto regulations issued by the executive, which is a huge power shift, and surely inappropriate. And then lastly, it would insert into the first section of our Constitution language that basically says there's no right to taxpayer-funded abortion or any other right related to abortion. And I think there are different legal opinions about what the implications of what this would be. I think the thought is that on the Republican side, assuming just for a minute that we end up with a Democratic governor and power remains divided in the next session, that sort of amendment could be in there, or other amendments related to abortion or anything else that would allow them to change policy, and also change policy in a way not just to sidestep the executive branch, but in a way that the judicial branch would not have a say as well, right? So this is a big deal. It's kind of been simmering for a while, not quite boiling yet because none of these amendments are going to heading to the ballot. But it's worth naming because it's going to be related to voting access, election integrity, and then also the issue we're talking about this afternoon. So I'll stop there, and thank you again so much for having me.
Thank you very much, Pat. Samantha, let's put him on the faculty. Maybe we can teach state and local on a regular basis. That would be very helpful. One question I have. What Pat was mentioning, if you recall in the last presidential election, we counted ballots through the night. We counted mail-in ballots through the night, and the reason was because they were not permitted by law to open those envelopes and do what's called pre-canvassing, unfolding them. They're folded ballots, which eventually have to be fed through a machine. And that meant that we went to bed not knowing the results and not until the next morning. And that lent itself to all kinds of nonsense about integrity. Florida has the same mail-in ballot procedures that we have, with one difference. They pre-canvass their ballots as they come in, and by 8 o'clock that night, we knew who won Florida. And we had to wait 2 days or so to find out who won Pennsylvania. And all it would take would be for the legislature to allow the various election commissions in each state to pre-canvass those ballots, open them, put them aside, and count and feed them through the machine. And do you know anything about whether that might change for November?
The pre-canvassing issue? Surely no. We've been calling for it for a couple years. Election directors have been begging for it, and it's not going to happen.
Makes total sense. Okay. This brings us to the third portion of the program, and that is the goals of the pro-choice and the pro-life factions relative to shaping legislative policy. Leading discussion would be Melissa Reed of Planned Parenthood and Marlene Downing of the Susan B Anthony list and the Bucks County Pro-Life Coalition. Before we do that, we're going to play a 2-minute video that kind of lays out, I don't want to use the word battleground, but the Supreme Court threw this to the states, and the states will decide what the abortion laws are for Pennsylvania. And basically, this is a video where both sides are saying voters need to mobilize, voters need to know what's at stake, and vote their values on either side, and elect people that, or at least shape policy in the way they want it. While the video is being played, I'm going to collect those cards. If you'll pass them to your right, and here we go.
After voters in Kansas rejected a constitutional amendment that would have allowed state lawmakers to ban abortion, eyes are turning to other states considering similar amendments. As political editor John Delano explains, Pennsylvania is one of those states.
Because the state House and Senate are controlled by Republicans who oppose abortion rights, a constitutional amendment that would clear the way for anti-abortion laws passed both chambers last month. But to get this amendment on the ballot, it has to pass the legislature next year. That makes this November's election really key.
This constitutional amendment will be voted on again in this next legislative session in January. And so it's very important for folks to understand how important the election to the General Assembly is.
If more pro-choice candidates are elected this fall, says Lindy Malden with Planned Parenthood, the constitutional amendment will die. Maria Gallagher with the Pro-Life Federation agrees on that point.
This November election is crucial in order to determine the status of the Pennsylvania House and Senate. We have good, strong, solid pro-life majorities in both the Pennsylvania House and Senate, and we want those majorities to continue.
If that happens, says Sue Fritche, senior attorney with the Women's Law Project in Pittsburgh, not only will the amendment get on the ballot, but in the legislature,
they could pass every crazy anti-abortion thing that you've ever heard of. We would look more like Texas. I would not be at all surprised if we saw a complete criminalization. We would have doctors going to jail.
Michael Geer with the Pennsylvania Family Institute that supports this constitutional amendment thinks abortion is one of several issues that voters will consider this November, when half the state Senate and all state representatives are up for election.
Voter registration have been shifting in a conservative Republican direction because of what are people looking at the landscape, what's happening in Washington with the radical policies of the Biden administration on things like abortion.
Do you know where your state representative and senators stand on abortion rights? Are they pro-life or pro-choice? And what about their opponents? It's not clear yet whether this issue will draw more voters to the polls than usual, but you can count on both sides talking about it in the months ahead. John Delano, KDKA News.
Thank you. Marlene? Melissa, I'm sorry, Melissa, yes. Yes, 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 please.
Okay. Good afternoon. My name is Melissa Reed, and I'm the president and CEO of Planned Parenthood Keystone. We cover 37 counties in Pennsylvania, including Bucks County, and within those counties, we have 8 health centers and provide comprehensive reproductive and sexual health care to about 24,000 men and women and non-binary folks every year. The majority of the care that we provide is preventive in nature, so it's birth control, it's life-saving cancer screenings, including breast, cervical, and testicular cancer screenings. It's STI testing and treatment, and gender-affirming hormone therapy. But we are also a proud abortion provider and have been for decades. When Dobbs was overturned, sadly, we were prepared for it, and we had been preparing for years because we could see the cases that were coming up to the Supreme Court. We could see who was being affirmed on the bench, and we knew that our right to bodily autonomy was soon to be stripped from us. And as John mentioned, it's the first time in our nation's history when a constitutional right affirming a liberty has been taken away from American citizens, especially one that we have had guaranteed to us for almost 50 years. So what have we seen since then? What we've seen is, as of today, 17 states have banned abortion care. We expect another 9 or 10 to move quickly to ban abortion in the very near future, within this next 12 months. That will mean that the majority of our nation's women will no longer have access to abortion in their state. Already, for those states that have banned abortion, the average travel time for someone seeking, or mileage for someone seeking abortion, is 400 miles. 400 miles. Now, let's be clear, people who have wealth, who have transportation, they will always be able, or probably be able, to access the care they need by hopping on a plane or train or getting in their car. But for tens of thousands of other women, it means they are going to be forced into pregnancy. And what I believe, what Planned Parenthood believes, and actually 9 in 10 Pennsylvanians believe, according to a recent FNM poll that was released, is that abortion should remain safe and legal, that ultimately the decision whether to become a parent or end a pregnancy or to choose adoption should be with that individual, with that woman, in consultation with her faith, with consultation with her family, consultation with her doctor, and not in consultation with government officials. I don't consult my state senator when I need to have a mammogram. I don't consult my state senator when I want to have another type of medical procedure. And it is unconscionable to think that our legislature should have a role in those most deeply personal and complex decisions. So what are we doing here in Pennsylvania to prepare? And how have we prepared? Because we're expecting an additional 8,500 women and people who can get pregnant coming to Pennsylvania every year for abortion care. So we have been hiring additional providers. We have been offering abortion through telemedicine. We are able to mail medical abortion directly to patients' homes in Pennsylvania now to reduce those barriers. And we have added appointment availability in all of our health centers And just this week, we were very proud to open a new health center in Lancaster, Pennsylvania, which will be offering medical abortion next calendar year. So we've been doing a lot to prepare, doing a lot to make sure that people have the access that they need and they deserve. However, as you've heard from the clip and from Patrick's statements, this ballot initiative that could be coming before Pennsylvania voters as early as the primary in 2023 is that the legislature is working hard to bypass the governor's veto so that they can pass further restrictions here in Pennsylvania and eliminate that right to choose an abortion if one needs one. It also, as Patrick mentioned, eliminates state funding. Now let's be clear, Medicaid currently in the state of Pennsylvania only covers abortion in the case of rape, incest, life of the mother. This would go further and say there was no coverage at all, and that if you were a state employee of Pennsylvania, that your personal medical insurance covered through your state employee health plan could also no longer cover the care that you need. Planned Parenthood believes that your medical care should not be dependent upon your zip code or on your health insurance plan or how much money you have in the bank. You should be able to get the care you need. So we are going to fight like hell to defeat this ballot initiative, but also the Pennsylvania legislature has been working very hard to introduce other types of bans. They've introduced legislation for a 6-week ban, for a Down syndrome ban, to control how medical waste is disposed. And so they are taking lots of different tactics. And we have been fortunate to have Governor Wolf in his position to veto these bills. And so we are also working very hard to educate our legislators on the real world impact, like we're seeing in Texas, where hospitals are now saying a woman has to develop sepsis before they can remove an ectopic pregnancy, or if a fetal demise is happening, that she has to be sick enough to where she's almost dying before they can take action. We are seeing pharmacists refuse to provide medicine for things like rheumatoid arthritis because those same medicines have been used as a medical abortion. We are seeing people denying a 10-year-old an abortion who's been raped, so she has to travel far away to be able to get the care she needs, because that state says she is not only a citizen of a state where it's banned, but she's not mature enough to make a decision about abortion. However, she's mature enough to carry pregnancy to term and become a parent. These rules are unjust and they're cruel, and that's the point. And it's going to create huge economic disparities, greater than we're already seeing, and it's already creating a public health crisis. It's incumbent for all of us to fight against these types of cruel policies.
Thank you very much. Marlene, are you comfortable speaking there? You're good there?
Hello, everyone. So, let me fix this real quick. I can never get these mics right. I am Marlene Downing with Susan B Anthony Pro-Life America. We are an organization that are advocates for pro-life laws, and we stand for life. Basically, right now in our states, we have a race that's coming up in the Senate and the governor's race that is very important to us. And the reason why it's important is because life is on the line and we need to stand up and be able to be counted. Just listening to everyone up here, I appreciate your input. It's very important that we get all views, but also to also know the truth and the facts as well, which is something else that we need to talk about. So I just wanted to start off, I had an idea of how to start off, but I really want to start off with the reasons that people seek abortion and that percentage, the percentages that we're talking about. Because there's a lot of fear that's going on, and a lot of that has been created by the media and other places. So I just wanted to just talk about like the percentages. So with rape, there's 0.3% of women seeking abortions for rape and incest. Life of the mother, 0.02. I'm sorry, 0.2. Fetal abnormalities, 1.3%. Physical health of the mother, 2.5%. And then the rest of them, the 95.7%, are elective and unspecified. That is what's happening. So when we talk about the fears that we have of rape and incest and everything that's going on, we know that we live in a fallen world. We know that there is just a lot of things that are going on that just should not be happening. Rape is a terrible thing, and people that perform such things should be prosecuted by the fullest extent of the law. But we're talking about abortion here. We're talking about life. We're talking about life. Can I say that again? We're talking about life, okay? And going back to, sorry, my notes, because I really didn't plan to, I thought we were just gonna have a panel, but I'm talking, so great. So basically going back to the founding documents, our Declaration of Independence, we talk about, the statement that they held is that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That's our foundation. That's what we were built on. So now, because of our world, because it is fallen, because it has gotten so terribly bad, we forgot about life. I totally get that people are going through so much that they can't really see past that, see past what's going on in our world. It's just really hard to see past that. But I'll tell you that I am a post-abortive woman. I'm also an African-American woman that understands that in our population, what we're dealing with is just a lot of things that have to do with self-worth. And that's the solutions that we should start looking for, is how do we create solutions instead of using abortion, which is death, as the solution to our problems. It's not okay. When I was looking to, just make some points, I came across the Emancipation Proclamation because we wanted to basically talk about slavery as it correlates with what we're dealing with now. And we know that was like, the major fight back in the 1800s, in the mid 1800s. But when we're thinking about somebody that we looked up to, or that people look up to, Abraham Lincoln, who wrote that Emancipation Proclamation, just understand that he was actually where some of you are now. He wasn't like fully persuaded that what he was doing was the right thing for slaves. He was persuaded by the fact that he wanted order. He wanted to end. It was so much of a struggle on him to have to deal with the weight of what was going on that he said this: my paramount object in this struggle is to save the Union. And it's not either to save or destroy slavery. If I could save the Union without freeing a slave, I would. And if I could save it by freeing all slaves, I would do it. And if I could save it by freeing some and leaving others alone, I would do that also. So you can see the conflict within him, because I don't believe that everybody that is for abortion is a bad person, but I believe that you have your perspectives wrong. He wasn't looking at the slaves, he was looking at trying to fix an issue, but he didn't have the right perspective. But I just need you guys to understand that we all should have a right to life. And in our Constitution, it never gave that right to abortion. I don't care if you want to say that it was implied. There was never a right to abortion given. So that's why we stand here today as people that understand that Roe versus Wade now, within 50 years, that was only God that did that, is now overturned. And now we can go back to the states, which still doesn't stop our problem, our pro-life movement. It still goes on. We are still facing just a lot of egregious evils within the pro-abortion world, and we will continue to fight. But that fight has to be done in a legal way now. And it's going to go by you standing up and going to the polls and doing what you have to do to stand for what you believe in. And so that's why we need everyone to come together and do that. So I just say that, again, as a post-abortive woman, as somebody that knows what abortion does to a woman, it's a lot of psychological, it's a lot of regret, it is a lot of damage that it does to even your family. You know, my daughter, now that she knows that I had an abortion, she's 12 years old now. It bothers her, you know, that she could have had 2 other brothers and sisters. Life is important. It doesn't matter what anybody says. What does God say? And so I didn't want to make this a religious talk at all, but I am firmly rooted in my faith. And I believe, of course, that everybody should have freedom of religion, which is why also we are an endangered species, the people that do believe in this way. But I just really would love for us to, at some point, come to an understanding of the common ground that we should be in, and that is to know that life is worth living. Thank you.
Thank you, Marlene. And I want to again, congratulate the panelists and the audience for your decorum today. We just have just a little bit of time left, and I tried to synthesize these questions. They're all over the place. But I do have a question I'd like to throw out to the pro-choice and the pro-life representatives, and you don't have to answer them, but I'm just trying to ask them as fairly as I can. And I'll ask them both, and then you guys can respond as you see fit. One is, what services, or is it part of the mission of Planned Parenthood, if a young woman has a pregnancy that she's struggling with and decides to keep the baby to term, are there any services that Planned Parenthood offers in that regard? Hold on to that for a second. That's one question. And the other one is, assuming your statistics are correct about the number of abortions that are not just elective as such, what is your reaction to those, terrible stories about a woman who might have to go through a pregnancy that is life-threatening or whatever? And either one of you could go first or respond to each other.
I can begin, thank you. So, Planned Parenthood believes that people who come are facing a pregnancy decision should really have all their options laid out for them and counseled about. And so we make sure that we do that. And if a person decides that they want to continue the pregnancy and needs some additional resources, then we have really strong referral relationships with OB-GYNs in our community that can help with prenatal care, with midwives, with doulas. We also make sure that they get prenatal vitamins started very quickly. And what other social service organizations that could provide additional assistance with funding, with food, with shelter, whatever that individual needs, we make sure that we provide really wraparound care for that individual.
Thank you. The other day, and I know we tend to pick the most egregious examples of things. The other day I heard a woman saying that the doctors have told her that the fetus she was carrying had half a brain, was paralyzed, and 3 or 4 other things, and lived in a state where she was already beyond the time for an abortion, and one of those new state laws. And she said, basically, I'm carrying this baby in order to bury it. What is your reaction to that?
That's a very hard thing to deal with. Just even imagine if she got to late term and had to understand that her baby would not be born with all of its brain. That's something that's very, very tough. I was speaking with a very good friend of mine. Her name is Dr. Monique Ribeiro, and we were talking about this with someone else because they were saying that their baby was going to be born without legs, and they got second opinions, and they knew that their baby was going to have all of these defects. And so, what she said, because I can't speak to what a physician would say, but she knows. She said that there can be a birth that takes place instead of a willful, intentional killing of the child. So they can induce the birth, and then they can really mourn the death and give the baby dignity and life, even if it's for a second. So there are options besides abortion to make this come to pass, but when you do the act of abortion, that's an intentional killing of a child. That's the way she explained it. So that's actually what I believe. If I was a mother and that was my case, that's how I would deal with it, even though it would be painful.
Okay. And the last question is, all right, come on. We've done so well for so long. Come on. The last question is, as this whole thing is geared toward the legislature is going to be determining the law in Pennsylvania, and what do we as citizens do about that? Is there room for compromise from you, or from your group, or your group, in terms of what the new abortion law should look like?
Well, as far as I'm concerned, I don't think you can compromise on a woman's health and bodily autonomy. There are already significant barriers in place in Pennsylvania for people to access abortion, and quite frankly, they're unnecessary and they're unrelated to good quality medical care. So I believe that those need to be, the Abortion Control Act, that parts of that need to go away. And I also believe that citizens do need to educate themselves, register to vote, and vote. But I also know that these same legislators who are trying to ban access to abortion are also refusing to allow comprehensive sexuality education, and they are also trying to restrict access to contraception. So what they are really doing is removing all the ways that a person has to control their reproductive destiny. And so I don't see that there's a compromise there.
Thank you. And Marlene?
So ultimately, it's going to come down to the law, and whatever incremental saves that we can do, that's important to us. If we save one life, that's generations. That's how I feel. That's how we feel. However, there is a time when we know that a baby can feel pain in the womb, And I believe that that is one of the bills that have come up as well, is when a baby can feel pain in the womb, and I believe they're starting at 15 weeks or thinking about starting at 15 weeks. That's something that I don't compromise myself, but if I was to vote on a law, I would rather have the least of what is presented. So right now in Pennsylvania, the maximum or the limit is 24 weeks, which I think is terrible, because that's 6 months. We're looking at that, and the baby is just really developed at that point. But life starts at conception, so I would be probably the wrong person to ask for that.
And you know, obviously you don't speak for all pro-life people, and there are varying points of view. But I hear you saying something. Well, when I hear a candidate for office saying, I make no exceptions for rape, incest, or life of the mother, or anything, you're not necessarily there.
I'm there.
You're there. But if the new law wasn't there, but was something more restrictive, you would see that as a victory. You would see it as a move in
Every
direction.
incremental win is good for us.
Melissa, I saw you shaking your head about something.
Oh, I was shaking my head about her myth about fetal pain, that there is no medical science to support that a fetus feels pain at 15 weeks.
And I have no idea, right? So I want to thank you. I want to thank you all for a very informative discussion, from the legal basis on how we got here in the first place to...
She needs a rebuttal. She needs a rebuttal.
Okay, Joe, do you have a rebuttal to it? We can share our non-scientific... Excuse me, Joe, I'm speaking and you're not. We can share our non-scientific backgrounds, and I'm not sure where that will get us. You believe a fetus feels pain. You believe it does not. I think we can leave it there. Okay? Okay. Now, I'm going to introduce Samantha Gross, the Dean of the Social Behavioral Science Department, for a brief announcement.
I wanted to just take a minute to thank you all for joining us today for a very current topic, one that of course evokes a great deal of passion from many of us. A special thank you to all of our panelists, very informative, very heartfelt, and so thank you. And a special shout out to our students. Where are our students who have, I see familiar faces, so I know you're here. Okay, good. Shout out to all our students for taking time out of your day. Yes, to our students, time out of your day to go and learn a bit more about what's going on in our world. Also, we're going to have our Congressional Debate, is it the 25th, October 25th. We'll be back here for the Congressional Debates, and I hope to see you all there. And if you liked what you know, sort of the atmosphere and stuff, we have courses open to the public in politics, history, ethics, and so on. Feel free to visit our website and check out the many courses that we do offer if you'd like to continue your journey and continue your education. Thank you so much.